Don't interrupt.
Are you dealing with me
got
or
a
him or
horrible
them?
hip.
He's
You got
switching
a-
me around. Why don't you stop switching me the fuck around, bro?
How about you stop talking and listen?
Nah,
My bond is 40,000.
10%. It could be
Can't be
40,000
because
cash if you use
it
the
can't be
F-bomb
because
again.
I have 2 misdemeanor charges, bud.
Sit back.
We're going to trial then, bro.
Sit back.
It can went from $750 to 40,000 over nothing. I'm fucking this whole state up then, man.
You got
We're going
about
all the way to
15
Supreme Court. We're going to court on this.
You got about
You
15
can't sit there and take me from a $250 bond to 40,000 for nothing.
You just used the F-bomb. You're disrespectful. I think you're a
No,
flight
I'm not.
risk. You got 15
I'm
criminal
not. How am I a
convictions
flight
on
risk?
you. Listen,
I live right here. This is I don't even have a car.
Stop interrupting.
I can't
40,000.
hear for one.
well, you seem to be able to hear when you started to defend yourself. 40,000, 10%. You cannot leave the state, cannot violate a law.
So you keep me in
unless
jail
it
the whole
appears
time?
15 days of the date of the arraignment. You have the right to a preliminary exam within 7 days of the date of the probable cause conference. If I adjourn this for a week, that means that the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, sir.
Do you wish to waive that right?
No, sir.
You want to go to the exam next week?
Can I speak to my attorney in a breakout room again?
As you say, the reason that we're adjourning this is because we just met and we're going to look through the discovery. Is it all right if we have that extra week? Do you agree to adjourn that for one more week in order to review the case with you?
If you want to go next week, we'll go next week. It doesn't matter to me. What do you want to do? Sir, talk to me. What are you doing? Talk to me.
I want to do.
Your lawyer wants me to adjourn it. I'm willing to adjourn it. If you don't want to adjourn it, we won't adjourn it. It's up to you.
Yes, I'm willing to adjourn it, sir.
So you waive that right?
Yeah.
Yes.
Anybody force you to do that?
No.
I'll adjourn the PCC to June the 16th. What time are we going to do that? And the preliminary exam to June the 23rd.
June 16th at 8:45 and June 23rd at 10:45.
Okay? 8:45 next week, 10:45 on the 23rd.
Thank
Okay?
you.
So June 16, 8:45, PCC, preliminary exam, June 23rd at 10:45. Anything else, Ms. Tucker Davis?
No, Your Honor, thank you.
Have a good day. Thank you. We'll see you then, sir. Good luck to you.
You
Thanks.
can hang up now.
Tawas Trucking, did they show back up? Oh, no, we just agreed to adjourn it, right, Lisa? Yeah.
Turned it
Or
1
he was-
week.
Or he was gonna call. He was
No,
gonna call.
he said he was out of town, out of the country, so we adjourned it 1 week.
Okay, good enough. What else do I have here?
I'm getting it ready.
Okay. All right, people against Griffer. Ryan Joseph Griffer, 26B 711-925.
Good morning, Judge and staff, and the young legal assistant next to the judge.
Your name, sir?
John Graziani, attorney on behalf of Mr. Ron Gopher, who's standing my left. Please identify yourself, sir. Ryan Joseph Griffin. Judge, as you can tell, we're seeking an adjournment of several weeks for additional information. But a very important thing right now in the sheet is the fact that Mr. Griffin be allowed to be back home. It appears that the alleged victim has moved off the premises, and I just want to make it.
Let me. Is the victim here by chance?
I do not believe that she's here. I spoke very briefly to Ms. Alawi, and she didn't indicate whether she was here or not.
There was somebody.
Was here. I put her in a breakout room with the prosecutor, and then I haven't seen her since.
All right, so I'm gonna redo these bond conditions. Mr. Gripper, you're not to have any contact with the victim in this case. Jennifer Michelle's. Or Michaels, Michels, no contact, or you cannot, no contact with her. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. I'm going to give you a new court date momentarily. You cannot possess firearms. You're not to purchase, possess, or consume alcohol or illegal controlled substances. No firearms, no dangerous weapons, no alcohol, marijuana, or illegal drugs, no contact with her. I'm not going to have any prohibition against you going back to the property address. I'm told that she moved out. And that's it. So you can go back there. And we are all set. We'll give you a new date. Is 2 weeks enough?
2 weeks is fine, Judge.
So we're gonna do the 23rd, Lisa. Do you have time?
Yes, 9:15.
9:15. Okay, sir. Do you have any questions? Okay, you can go down the hall, get your notice. Good luck. Thank you. People against Leone. Matthew Blake Leone, 26G710217.
Good morning, Judge and staff. John Graziani, looking on behalf of Matthew Leone, and we're asking for an adjournment.
Sir, your name?
Matthew Blake Leary.
Is 2 weeks gonna suffice?
2 weeks would be fine, Judge.
Yeah, let's adjourn this one but if it's not resolved, I'm gonna have to set it for trial, okay?
Understood, Judge.
We'll set it for June 23rd. What time do we want to do this one, Lisa?
9:30.
At 9:30, okay, sir?
Sir.
So you can go down the hall and get your notice, and we will see you back here then. Thank you.
Thank you.
People against York. Denise York, 26 S577060A. Your name, ma'am?
Denise York.
You're charged with driving on a suspended. I have a note here that says you paid the speeding ticket. You have the right to an attorney. If you want one, I will give you one. Would you like an attorney?
I just want to deal with pay whatever happens.
So you waive your right to an attorney?
Yeah.
On May 16 of 26, it is alleged that you did operate a motor vehicle with a suspended license. They think you were operating that vehicle at Elizabeth Park in the city of Trenton at 2:15 PM. They think you had a suspended license. That is a misdemeanor, punishable by up to 500 fines, 93 days jail, costs you all those 2 points. You understand that?
Yeah,
And did you sign, read, and understand the advice of rights?
say that again.
Did you sign, read, and
Oh,
understand?
yeah, I'm fine.
Did you read it and understand it?
Yeah,
If you plead guilty at any time, you'll be giving up all those rights. And we will not be having a trial of any kind. Do you understand that?
yes.
All right. I'll enter a not guilty plea. If you still wish to waive your right to a lawyer, I'm going to send you to the prosecutor. You can talk to them
No,
now.
I just don't.
Okay, you're going to go talk to, this is a criminal charge. I just want you to be aware.
Okay.
I'm not saying you're going to jail. I just told you the maximums. So I will enter a not guilty plea. You go negotiate with the prosecutor. If they don't give you what you want, then you can come back and tell me you want a lawyer, okay? I can't hear you.
Have a seat in the hallway, man.
We're gonna set you up. The prosecutor will speak with you then. Thanks. Justin Scholes,
Yes, sir.
502-6D-827-956. Your name?
Justin Scholes.
All right, so you are going to be a winner today. A case dismissed. The officer failed to appear. So I'm going to go ahead and dismiss it. The officer failed to appear. It says witness failed to appear, was told he was on his day off, tried to call his work Uber and received no response. Case dismissed. This was scheduled for 9:45. And he was given more than 15 minutes. It's 10:46. You're all set. Best of luck to you. Thank you.
Thank you, Your Honor.
Victor Matevsky. 680-576. Do I have Mr. Kazmarek out there somewhere? Did you have a lawyer?
No, last time he was here and I decided to fire him and come and present myself, you know.
Oh, yeah, I did allow you to withdraw. Well, I mean, you gotta tell us before defendants show up. Call the prosecutor in here, will you please? They want an adjournment. They want me to adjourn this. You don't want me to adjourn this, do you? Blaine?
I wanted to explain it myself and represent them, you make a decision. Because
You don't need to explain anything. He's not here. Counsel, your appearance?
Morning, Your Honor, last name, I've never go after the.
It's only 10:48, but it seems like 1 o'clock, doesn't it? Listen, I can't adjourn this. I mean, the officer has a conflict, but they gotta let him know before this. So I'm gonna, yeah, well, they gotta I'm not gonna make defendants show up here either, you know, and then, so I'm gonna just indicate officer failed to appear, case dismissed. You're all set. If you were texting while driving, please don't do that.
No, Your Honor, this was.
I believe you. It's fine. You don't have to explain. You're a winner. Go out of here and say you beat the system today.
I actually have to fly to Europe now to prepare with my family. I have $1 same as this beautiful and one with 87 months.
You're going to Europe
The flight now, yes,
today?
baptism to my baby. Yes, today.
Nice. Where are you going?
Macedonia.
Very nice. Well, you can go there as a winner today then.
Thank you. What is the next step from now?
You win.
This is my first ticket.
You win. You don't pay nothing. Nothing goes on your record. You're a winner. Okay? Happy baptism and be safe.
Thank you.
Good luck.
Appreciate
Damian Deshaun Butler. 260-706-769.
Good morning, Your Honor, and your staff, Attorney Quentin Dox, P number 79657. On behalf of my
Your
client,
parent-
Mr. Butler, Mr. Butler.
And good morning, Your Honor.
Mr. Butler, your name?
Damian Deshaun Butler.
So we still don't have a competency report, right?
That's right, Your Honor. It was evaluated around May 22nd, so it should be coming shortly.
All right, so how long do you want me to adjourn it? Just maybe 3 weeks?
Yeah, I think that's right, Your Honor.
All right, I'll adjourn the competency hearing until June the 30th, Lisa. And we can do 9:30 if you want, Mr. Dox. Good with you?
Yes, Your Honor.
Okay, that's what we'll do. We'll adjourn it until June the 30th at 9:30.
Thank you.
Docs was any significant limit? Is that?
You have an exam, Mr. Dox? Mr. Dox?
Yes, Your Honor, I'll be there shortly. I have an exam at 11 and a sentencing at shortly after that, too.
Is that exam going?
I'll speak with my client, Your Honor. I'm not sure.
All right, can you get here quickly, please, okay?
Yes, Your Honor.
Wilkins Alexander III, 26M665-269A and B.
Good morning, Judge and staff. John Graziani, attorney on behalf of Wilkins Alexander, who's to my left.
What are we doing on this? Your name's?
Identify yourself.
I can't go much longer than
Judge,
this.
the situation real quickly, there was a little bit of a shortcoming in the progress test, the parking thing, so we have to set up another one. This is why we're requesting for 3 weeks. Sorry for boring you.
I'm done. Yes.
I'm gonna go on report on this. Why don't you think about setting a bench trial
We'll set a bench trial.
or jury trial if you need to? I could, huh?
We'll set a jury trial for 3 weeks. We'll set a bench trial for 3 weeks.
Would you go get the prosecutor to waive a right to a jury trial? Have a seat. I'll set it for a bench trial in 3 weeks and then I'll be happy. Okay, sir? Why don't you
Still want me to get her?
please, well, you're gonna have her fill out a waiver form, bench trial waiver, jury trial waiver form. You can have a seat right behind you, okay? Right at that table there. Could I have Mashoud Hussein? 26B 711738. I'm waiting for your lawyer, okay? Lisa, they want an adjournment on this one too, so I could do June the 30th on this. This is not that old. It's a domestic case. But I'm gonna wait for Mr. Graziani to make his way back in.
I was looking for a bench trial or a pre-trial for this case.
Well, I can do another pretrial in 3 weeks, but wait for your lawyer. Just wait for your lawyer. Just wait, okay? He just went in on the other case and I. Okay, so we're on Hussein now, Mr. Graziani. Your name?
John Graziani, attorney on behalf of Mr. Hussein.
So I can do June the 30th as a final pretrial.
Yes, Judge, that would be fine. And also, there's a separate matter. Shame on me for not giving it to, the officer. There's an impeding traffic that you want to take care of.
June 30th at 9 o'clock on this one, okay?
Thank you.
So this will be a final pretrial. Okay? If it doesn't resolve, we'll go to trial on it, okay? Fair enough? Yes?
Yeah.
All right, that's what we'll do.
And there's a separate ticket that we want to address.
Okay, and I also got, Hussein, 26F, 245909. You got a warrant out for your arrest too.
No, I just paid that ticket today.
Your name? Your name?
State your name.
Oh, what should we say?
Your name?
John Graziani, attorney on behalf of Mr. Hussein.
You didn't pay this one, 245909, the impeding traffic, did you?
Oh, that's the one, trying to pay right now, or like, I'll pay it off.
Judge, with all the stuff going
That one's
on,
defaulted, Judge.
How much does he owe on that, Lisa?
185.
Can you pay that now?
Will I be able to go on a payment plan? Possibly.
2 weeks, can you do it in 2 weeks? Thank you, Judge.
I'll make a note, defendant owes 185. Defendant to pay by June 23. Now, if you don't have the money, it's not a problem. You have to call the court and set up an appointment. In other words, just set up a Zoom meeting with me, or you can come in here on or before the due date at 8:30, and I'll be glad to give you an extension, but don't ignore me again, okay? You understand?
Yes.
Okay, so June 23rd, you pay that by, all right? You have you're all set. You can go down the hall. If you want a printout, they'll give it to you, okay? Good luck. Counsel, do you have the waiver form?
I do not have the waiver form. She was with someone else, Judge. And I instructed her to come in. She'll be in her few minutes.
All right, I just need her to fill out a waiver.
That's right.
Andrew Webb, Andrew Joseph Ellis Webb. This is 26B82402A.
Is that the Brownstown or Flat?
This is Brownstown. Good morning, how are you?
I'm good, and yourself?
Not too bad. Where's Mr. Webb at?
Right here, Your Honor. Just right there.
Your name, Mr. Webb?
Andrew Webb.
I don't understand why you didn't show up for sentencing.
It was work. I missed the court date. I missed it twice.
Go ahead.
For the record, Your Honor, James Schwab, 30720. I spoke to Mr. Webb about this, and I asked the court to recall any warrants that are out for him.
We have done that.
All right, and
What's he doing? Why didn't he bother showing up? This was in April. You can't just come in here and tell me you got work. What are you doing? You end up in jail over a vicious act case.
Stupid, just stupid.
I also try to tell him the importance of coming to court. I believe he understands that. He has work obligations, but I told him that court has other obligations as well, and much tougher ones. So I would ask the court to give him another opportunity. He doesn't live that far away. I don't think he has a huge criminal history.
He doesn't, but he failed to appear April 8th. Then he came in the 13th and I rescheduled it for him for the 22nd. Didn't even show up again.
Did the court require a pre-sentence report?
No, it was a dog case. It was a vicious act case. Where do you work at?
Wallbridge.
What are you doing?
I'm stupid, just honestly stupid, forgetting, missing my dates, didn't have it down. I don't even want to make excuse. I messed up and I'm extremely sorry.
You have $200 with you?
I don't have it on me. But I have a card.
Yeah. You have a debit card?
Yeah.
We can have them use the debit card from there, right, Lisa? We've done that.
Does he have my wallet?
Yes, he can use the debit card at the police station.
10%. You do this again, I'm not going to be even this nice. Do we understand one another? This is silly. You've missed 2 sentencing states now.
Absolutely.
All right, we'll give you a sentencing date for June the 25th. June the 25th will be your sentencing. And that will be at 8:45. Now stop doing this. Post your $200 and show up that date. Okay?
Okay.
Come on. That's what we're doing. Good luck.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Robert Eugene Williamson, 260-245-827A and B. Your name, sir? Your name, sir?
Oh, Robert Williamson.
Officer, sergeant, your name or corporal? I can't tell.
Sergeant Mitchell.
James Schlock, 30720.
These guys don't get it, do they? Why didn't you show up? Why didn't he show up?
And my mail goes to, I'm in an apartment complex. And I don't get no, sometimes I don't get no mail at all.
You
for weeks.
remember getting stopped, right?
I'm sorry, what? I can't hear. I'm half deaf. I'm sorry. I'm half deaf.
All right, let me put it to you this way. You got stopped. I don't want you to acknowledge that you did, but at some point, it's going to be pretty clear to me that you did get stopped. If you had mail issues, you should have called the courthouse. You should have called the police department. Now you got yourself in a real predicament.
Soon.
What, is there a problem
Sorry.
with something I just said? I don't want you to cop an attitude with me. If you do, we're going to have a bigger problem.
No, I'm half deaf. I can barely hear you. I'm half deaf. I can't hear you. That's the problem.
All right. Can you hear me any better now?
Yeah, that's all the problem was. I couldn't hear you before. So what's going on?
Does he stand mute and wait formal reading?
Yes, Your Honor.
I'm entering a not guilty plea. I got an operating with the presence of drugs, and I got a resist, hinder, and obstruct an officer charge. So your lawyer's telling me you stand mute and waive formal reading. Has he been printed on this, Sergeant?
Yes, he has.
I want to know why he hasn't shown up.
I apologize.
Why did you not show up?
I didn't get notice.
Well, you knew you got stopped. You should have called the court. We sent it to 311 Adams. Is that your address?
That's my address, but sometimes things get dropped. Sometimes things get dropped. You know what I mean?
We sent 2 letters there. If they came back, we would have put them in the file.
Oh,
you were supposed to be here on April 30, and then you were supposed to be here on May the 14th, and you didn't show up either time, and I don't have any return envelope or any envelope stamped that was sent back to the courthouse, or it would be in the file. Where does he work?
He's on disability, brother. But he has no prior cases. He did tell me about his mail issues. And
he's got prior cases. I mean, he's got a heck of a history here. Home invasion, 98. Impaired, 99.
You can't hold that against me. You can't hold that against me. You can't hold none of that against me because that was over 12 years ago. You can't hold none of that against me. 10 years or older, they don't hold it against you.
sure, it is your history. I will tell the court that it is pretty old and you make the right conclusions based on that.
Oh,
Okay?
we're talking.
You can always.
I'm getting mixed signals. I'm getting mixed signals. Yeah, you're gonna talk about my history.
Well,
Just 10 years or older.
Really? Thank you.
I could just go to some trial with it and then show you that they kept me in the police station for 2 days before they took me to the hospital
Sir,
to even
we're
prove
not
that I had
going to
drugs in my
talk
system.
about the substance,
And
especially
they kept me for 15
in
days in
open
the hospital.
court.
And then,
You'll have
see,
an
now you ain't
attorney
doing
next
it.
time who
Just let
will
me go.
able
I'll
to
come to
discuss
court and I'll
those-
take care of it. I promise.
Sir,
I just
you'll
didn't
have
get
an
notice.
attorney next time who will discuss those issues with you. Today, we're just concentrating on bond.
I was reading your history as I was reading it
Yeah,
to
well,
myself.
you can't read my history because it's over 10 years
Yeah.
old.
Don't interrupt.
Are you
the
dealing with me
judge.
or dealing with them? He's switching me around. Why don't you stop switching me to fuck around, bro?
How about you stop talking and listen?
I'm going
I
to
can't
set
if
you
I'm deaf.
down now. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. If you're going to be so defiant, that tells me you're a flight risk. 40,000, 10%. No alcohol, no marijuana, no illegal controlled substances. None.
My bond is 40,000.
10%. It could be 40,000.
Can't be because
if you use
it
the
can't be
F-bomb
because
again.
I have 2 misdemeanor charges, bud.
Sit back.
We're going to trial then, bro.
Sit back.
It came in from $750 to 40,000 over nothing. I'm fucking this whole state up then, man.
You got
We're going
about
all the way to
50
Supreme Court. We're going to court on this.
You got about
You can't
15
sit there and take me from a $250 bond to 40,000 for nothing.
You just use the F-bomb. You're disrespectful. I think you're a
No,
flight
I'm not.
risk. You got 15
I'm
criminal
not. How am I a
convictions
flight
on
risk?
you. Listen,
I live right here. I didn't have a car.
Stop interrupting.
I can't
40,000.
hear for one.
Well, you seem to be able to hear when you started to defend yourself. 40,000, 10%. You cannot leave the state, cannot violate a law.
So you keep me in
must
jail the whole
appear-
time?
Listen, if you give me one more bit of guff, I'm setting this case for next October, and I'm setting a bond of 100,000 cash. You want to keep going on, tough guy? You want
I'm
to
not
keep
being
going
tough. I
on,
can't-
tough guy? Feel free.
I want a
Here.
PR bond. I want to go home. I want to go home. I want a PR bond.
40,000.
Please,
No,
please.
no, no. You're
But then I'm
disrespectful.
suing you then.
Good, sue me. Okay, come on, bring it on. Can't wait.
I'm never going to get out, man.
40,000.
Come on, man, don't do me like this.
Will the court
What?
give the soonest possible?
Yeah, I'll do that, but he's not gonna yell at me and call. use
I didn't
the
mean to yell at you.
F-bombs.
I can't. I'm deaf. I didn't mean to yell at you.
You use the
I
F-bomb.
apologize. Can we start over?
No,
Please?
no,
Can we start over?
no,
Please?
no. No,
Please, can we start? I can't hear you if I'm yelling. I'm not
You
a tough
use-
guy. I just.
you use the F-bomb with me.
No, I didn't.
Oh, you did?
I never cussed at you. I would not disrespect you. I just. I can't. I
Listen.
wouldn't disrespect you like that. I apologize.
Listen,
Please, my mom's dying right now. Will you please let me go home?
I'm convinced you can hear a lot better than you think, or at least letting on, because all of a sudden you were able to comprehend. Now, I'm not going to argue with you. I'm telling you, it's June 11th at 9:30. 40,000, 10%. One more word and I'm setting it for June 25th.
This is a different charge. Why are you doing 2 different charges? That's not me.
Sir,
What you
it's
read
gonna
right now
be
is that's
next
not me.
week.
June 11th. That's not.
We're gonna get you in front
It's
of
2
the
different
court,
people.
and the court could review your bond at that time. And you can discuss the issues with your attorney at that time.
Oh, you're my attorney. So I don't know how it's
didn't say
going
that.
on
I
here.
said,
I get 5 different things going on right now. That's all.
June 11th is your next court
Thank you,
date.
sir.
That's what they're saying.
One thing I've decided, Mr. Williamson, I'm not listening to tough guys. You got it? You want to
I'm-
play tough guy? Get into
I'm not playing
WWF
tough
or
guy.
something. I don't know what to tell you. June 11th.
I'm sorry. I apologize.
No, it's not good enough.
I'm half deaf. I didn't know all the screens were up.
I could set it, I could just find you in contempt of court.
I didn't know
Lock
that
you up
all
for
the screens
30
were up.
days. One more word, I'm gonna do that. I'm telling you.
I have mental
June 11th is a
disabilities. Just
couple
hold
of
on.
days.
I have mental disabilities.
Cut
Can
him
you give me
off.
1 second?
Cut him off, Lisa, please. Wilkins Alexander III. 267, 665, 269, A and B.
Good morning again, Judge. It's, yeah, John Graziani, anything on behalf. So
Is she in here? Did she come in with a waiver form?
I believe she did, Judge, and I believe she gave it.
Do you have it, say a waiver of trial by jury form?
It was.
Look, I don't think they're gonna complain if I take a waiver trial when I'm driving on a suspended. Does your client wish to waive his right to a jury trial?
Yes, Judge. It's, again, it's just too bad it has to come to this because this matter will be resolved.
Okay.
But I understand where you're coming.
Sue, sir, do you wish to waive your right to a trial by jury?
Yes.
You understand you have a constitutional right to a trial by jury?
Yes.
Do you understand that a trial by jury, 6 people would be impaneled over there, all 6 would have to agree that you're guilty beyond a reasonable doubt in order for you to be convicted, but by waiving your right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand that? You still wish to give up your right to a trial by jury? Anybody force you to do that? All right, now let's make sure. Is he gonna have a valid license in 3 weeks?
Judge, not to embarrass Mr. Alexander, he will have it. It was just a failure of a stupid parking section. I don't
What
even
is that, the parallel parking or?
parallel park. I don't
It's
even,
not easy. You know what you do? You go to the door, right? Make sure your door is lined up with the driver's door and start turning your wheel right then. You understand? Your passenger door to the driver's door of the parked vehicle. Then start turning your vehicle. It's easy.
get a spark vehicle or a little.
Let's do it on June 30th, Lisa. Is that gonna give him enough time?
Yes, it will, Judge. In fact, he's gonna be scheduling it with next days to get the money down.
You want it done? Okay. What time you want to do this, Lisa? 10 o'clock? I don't think it's gonna end up going.
Yes. Is this a bench trial? I'm sorry.
Yeah,
Okay.
bench trial.
Yep, 10 o'clock.
June 30th, 10.
Thank you, Judge.
Would you, okay. Any questions?
No questions.
He's not gonna yell at me now, is he?
No, I'm calming it down a little bit.
Huh? Not bad. Boy, I'll tell you. I can't imagine what my dad would have done, huh? 40, 50 years ago. All right, good luck to you. Go down the hall, get your,
Okay.
Lisa, I hate to do this. My sweet little granddaughter would like a donut. Can you have, which one you want? Huh? A glazed donut. Do you mind having
Yes.
somebody bring a glazed?
I'll bring it down.
Thank you.
Yep.
All right.
Would
Denise
you like one?
York. Glazed, I guess. 26S5770608. She's paid the B file, by the way. How you doing, ma'am? Your name?
Denise York.
All right, so we're gonna adjourn this pretrial. We're gonna set it for July. Do I have a judge on July 7th, Lisa?
Just doing PCCs with Judge Hessen.
What's that? Just doing PCCs?
Yeah,
So-
PCCs only.
So we're gonna do it at July the 14th, maybe would be my next date.
Yes, July 14th
wants
at 8:30.
She wants 3 weeks, so I'm gonna give you till July 14th at 8:30, okay? Okay,
So what do I need to go to the Secretary of State and?
I don't know, it says adjourn for 4 weeks for defendant to get license back. I don't know the status of your license. And then you make sure you try to go, don't procrastinate, so we can get it done with on July the 14th.
You say my date come back July 14th at 8:30.
Correct. Okay, let me just check something here. When's the last time you had a valid license? When's the last time you had a valid license? That's what I thought.
It's been a long time.
We'll go get this taken care of. It doesn't look like it's gonna be that big of an issue, but you gotta go take care of it, okay? Go down the hall, get your notice. Thank you.
Okay, thank you.
All right. I'm ready for Henry Franklin Joseph Lent if you are, Mr.
I am, sir.
Mr. Graziani. This is 26T725297. And I need to have the victim, know if the victim is here on this case, and that's Catherine Berlinski.
No, not on Zoom.
All right. Is anybody by that name in the courtroom right now? Your name, sir?
Henry Rhodes. Sean, here on behalf of Henry, we have no additions, deletions, or corrections, but we do have a statement to make.
Okay,
And we're hoping you adopt the recommendation.
all right. What would you like to say?
Judge, even though this is, major hiccup, a very stupid mistake that this gentleman made, he's a very decent individual. Even though he's a well-educated gentleman, like many of us, he's immature for his age, and he had a horrible lapse of judgment. With all due respect to the system, Judge, this young man's already suffered significantly. He's been terminated from his employment since last July. Because of this incident, Judge, he's unemployable, and it appears for the next 5 years, he'll essentially be unemployable from from the employment that he was involved with, Judge.
You went to the University of Michigan
For undergraduate, yes.
and you were gonna be a physician?
He is a physician, Judge. And with all due respect, Judge, like I said, it was a horrible lapse of judgment. Mr. Lett and I have had many discussions, and a lot of young people these days are casual in their conversations and in the dissemination of information. Many times, the new information age is something that is highly destructive, as we've witnessed. The AI age is one that can benefit society tremendously, but it's also one that can destroy persons, particularly in this situation. I believe that this gentleman next to me will be able to come back, but it's going to be a heck of a long time before he comes back. He is extremely remorseful. He's had notes that he sent to me, and he's just one of the most decent human beings that I've ever met. Again, this is stupid what was done, but like I said, we're living in a day and age where dissemination.
Why are you doing this to yourself? I mean, I'm looking at a kid here. I remember talking about this. I didn't realize you had this much going for you.
He's a
You
brilliant
went to
gentleman.
Cranbrook, you went to the University of Michigan, physician residency program. And then you do something silly like this.
Next. Judge, if I may interject,
Were you under the influence of alcohol or drugs at the time you did this?
No, not at all, sir.
I didn't have any evidence of that. Go ahead.
Judge, in this day and age, in this wonderful, and I'm saying it sarcastically, AI age, a lot of folks tend to be very casual about the dissemination of information, and I feel that's essentially what happened over here. There certainly wasn't any malicious intent at that time. And again, Mr. Lett is extremely remorseful. It's cost him his livelihood, and I've
So
advised him.
Corwell found out about this and they terminated you?
I finished my residency program and I had another job lined up.
Where?
At the same hospital, Courtroom Churchill.
Okay.
And then when they ran the background check, they found this charge was pending. So they withdrew their offer.
May I add, Judge, since that period of time, he's applied at numerous places, countless places, and has been unsuccessful. We discussed his future and that he's gonna have to take a sidestep. And he's gonna have to, he'll still be able to practice medicine, but it's gonna.
Yeah, but what's he got going on in the row? He also had a B and E without owner's permission.
Judge,
And he's got a pretrial in a week, or a
Judge,
few days.
with all due respect, the matter is blown out of portion without getting into tremendous details. This was a situation in which this gentleman tried to help out that individual who was having a mental breakdown, and he had a friendship with that person and knocked on the door responsibly had, again, no malicious intent. And in fact, that alleged victim did not even want to pursue charges. It is a family member of the alleged victim who wishes to pursue charges. Nothing happened there. Nothing was stolen, Judge. It was just simply to try to help out that individual, Judge. That's all that went on for criminal account.
One thing I've always said, do you want to say anything else?
Are you talking to me, Judge?
No, I'm talking to him.
I suppose I should say that I understand clearly now that what I did was wrong. And it wasn't just wrong, it was also directly harmful to somebody that I considered to be a friend and would never have wish to hurt. I don't have a good explanation for how my judgment would have been. So for that would everything that was acceptable. But I apologize to Mr. Lewinsky for what I did and became distressed that I caused her. I wish I could take that back.
Judge, in this, you had numerous people who've done some very, very stupid things in this courtroom. There was one individual years ago who did stupid things, and this individual is in his 60s now. And that individual never received help. Mr. Lent is receiving extensive help, and he's going to be even more aggressive. And
help where?
It with group therapy, through psychiatric help, through medications, Judge. Mr. Lent realizes that this can't happen again. Otherwise, he'll be permanently
Well, what is he undergoing at Rochester? I wrote down a psychological evaluation and treatment if recommended. Are you seeking, and have you been in mental health treatment?
Yes, I've been seeing a counselor for about the past 2 years.
Yeah.
Rochester Area Counseling Services.
He's also seen a psychiatrist, Judge, and he's taken it very seriously, which he should.
I mean, you must be a bright guy. You know that? You must be a bright guy. I mean, you don't get through Cranbrook and University of Michigan and become a physician unless you're bright and work hard, but you got to use your head. I mean, you just got to use your head.
Yes, I understand.
It's nothing worse in my view than going to your grave at some point, whether we saying I underachieved. I just can't even imagine that. I'm not going to adopt this recommendation. I think he's remorseful. I think what he did was ridiculous. I told him that. I raised my voice with him at the time of the pretrial. But I still have a heart. 12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. Continue your mental health treatment.
Yes.
Is that all at Rochester area counseling?
Yes.
Continue that. I'm not going to pile on with the rest of this, and I have no evidence that alcohol was involved or drugs were involved at this. I know he had a drunk driving 4 years ago, but I'm not going to order that. No contact with Catherine Belinsky at all. You cannot write, phone, see, text, email her, or communicate with her, or have anybody else do any of those things for you or on your behalf. You're going to serve 48 hours of community service. Could have been a lot worse. I do not like this kind of thing. We don't embarrass one another. 48 hours of community service by August the 10th. 48 hours of community service by August the 10th. Fines are 100, costs are 275, victims' rights fee $50, justice assessment $4.25. Probation fees are $240 for 665. Screening fee is $60. $725, attorney fees of $40, $765. If you violate your probation, could be revoked, you could be incarcerated for 90 days. I don't know why. I'm going out of my way here because I truly believe you're remorseful. But you gotta make sure this is the last of your mistakes here.
Yes, sir.
We can't afford to make mistakes. We need to make mistakes, but not mistakes like you're making.
Judge, I explained to him that a man that appeared in front of you a number of years ago was always doing some very, very stupid things, and now he's in his 60s and he is in the Michigan State prison system. Minimum security, but nonetheless, because of the stupidity and failure to address these issues, he's messed up.
All right, can you pay this now or do you need time? If you need time, I have no problem.
Judge, I would request time.
How much time?
Can you do it 2 months?
Yes.
I'll just make it September 1st. You pay it when you can. I just sent you remorseful. I'm taking a chance now. Don't let me down.
I appreciate it.
But if you violate, you're gonna get 90 days. Do we understand that?
Perfect.
Good. Have a good day. Good luck to you.
Thank you so
You'll
much.
meet with probation.
Please.
I don't know which one to take next. Which one? Do you have a preference?
Judge, I have no preference, sir.
Nicholas William Kalicki, 26. And give me 1 second here. 26W7095671. Your appearance, sir?
John Graziani, appearing on behalf of Nicholas William Politis to my left. Please identify yourself, sir.
Nicholas William Politis.
All right. Do I have the victim here, Sarah Hancock? Is she here either on Zoom or in person?
No, not on Zoom.
Is it Haycock or Hancock?
This Hancock, I believe.
Yeah, I think so. All right. She's not here. Have you had a chance to review the report with your client, and are there any material additions, corrections, or deletions?
We've had the opportunity to review no additions, deletions, corrections, Judge. We ask that you adopt the recommendation, and there's been a tremendous amount of suffering. Families here, it's not divided, but they're very sad. The mother and father are in the second row to my left, and
I'd like to talk to Sarah Hancock too. Using language like that. I hate that racial. So she was no choir girl either in this incident.
absolutely, Judge. Absolutely.
But it's not to say that the conduct is justified. Conduct is not justified by words. But still, I mean, that's just terrible language to use. And in fairness, your girlfriends flipped her off and said, F you, mother effer, and then she responds with F you using the N-word. And it just escalated. But why would she get out and say F you, mother effer, your girlfriend? Where's she at? Is she here?
She's not.
They never show up when they do something stupid. I mean, seriously. Right?
Yes.
Yes.
And you got a good lawyer here. But anyway, you want me to adopt this?
Yes, sir.
Would you like to tell me anything, sir?
I can say that I'm sorry that all of a sudden that happened. I'm very remorseful.
This is still your sister.
Yes, she is my sister.
I don't understand people that they don't understand these relatives infighting thing. I mean,
Judge, if I may interject again on this, his sister is a former officer in a local jurisdiction who suffered a closed head injury, which exacerbates the relationship. And I've indicated as a result of it, that Mr. Kalicki should avoid her, and prior to going to his mother and father's house, he visits them on a regular basis, that he contacted them first to make sure that his sister's not there. It's going to take a long time for her to be rehabilitated if she's ever rehabilitated. Closed head injuries, as you know, Judge, are Pretty serious.
Did he spend any time in jail on this? No.
I spent 2 days in custody.
2 days?
Yes.
You did?
Yes. 2 nights sailings.
All right. Anything else anybody wants to say?
Judge, in lieu of, court work program, if he could do the community service, he has been working a little bit extra at the fact, again, that's what I'm asking for it. So at least he has some more flexibility. Court work program isn't as awesome. That is it, sir.
12 months probation, you take it under 76948. I'll need a review hearing date. You cannot leave the state without the consent of the court to violate any law or ordinance. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No contact with the victim, Sarah Hancock. You cannot write, phone, see, text, email her, or have anybody else do any of those things for you on your behalf. You're not to possess firearms. You're not to possess dangerous weapons. You're to obtain and maintain employment and provide proof of that. You're to serve 4 days jail. I'll give you credit for 2. I'll have you serve the other 2 on the court work program. There's a $35 charge for that. You're to attend the domestic violence program with 4-week follow-up. Attend that, complete that. Fines 100, costs 175, victims' rights fee, $50 justice assessment fee. So your fines and costs are 3 1/4. Probation fees are $240 for 565. You have a screening fee of $60. You have attorney fees of $40, court work program fees of $70. Your total here amounts to $735, I believe.
That's correct.
Did that, wait a minute, did I add the attorney fees for $40 or $40?
Yes, attorney fees of 40.
And the court work program fees, good enough, $735. If you violate, your probation could be revoked, you could be incarcerated for 93 days, you have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer. Do you understand that?
I do.
We're gonna give them a review hearing date, Lisa.
June 1st to 27 at 9 o'clock.
June 1st of 27 at 9 a.m. Does he have all this to pay?
Judge, he has most of it to pay. You put about $300 or $400 down to
Yes.
pay. I'm asking for about 2 months, Judge.
$300 down, and I'll have you pay $75 bi-weekly starting beginning June the 22nd, okay?
Thank you, Judge.
So 75 bi-weekly. If somehow something happens, you need more time, call the court. We'll go on Zoom. I'll be glad to give you an extension, okay? Good luck to you. You'll meet with probation and you'll get your review hearing date. You okay? Are you getting? All right, Charles Pawan Boyd. 26W706-997.
Good morning again, Judge and staff. John Grotzky, attorney on behalf of Charles Boyd, who's to my left. Please identify yourself, sir.
Charles Boyd.
All right, I just want to make sure that, first of all, let me just make a record here. His daughter is Tahari Boyd, and I want to make sure that neither she nor Janet Johnson are on Zoom. They're not in the courtroom. There's nobody in the courtroom. Can you confirm that neither one of them are on Zoom, Lisa?
They're not on Zoom.
So have you had a chance to review the pre-sentence report here, and are there any material additions, corrections, or deletions?
Judge, there's no additions, deletions, or corrections. We're asking for basically some guidance at this time, Judge. This is a very complex situation with Mr. Boyd. Mr. Boyd is the custodial parent of the victim in this case. Mr. Boyd's ex-fiancee, who currently is with the daughter, doesn't have custody and doesn't have the capacity to take care of the daughter. This young lady is going to fall through the cracks if we don't address this issue. I'm going to ask that maybe the probation department be involved, or possibly the circuit court, but I believe it could be handled by the probation department. What's happened, Judge, is, the daughter hasn't been in school since April 6th. She'll have to attend summer school at least. If she wants to graduate next year from Brownstown Woodhaven High School. And Mr. Boyd has to at least address the transportation issue. It's just a big mess right now, Judge. And without affecting the terms and conditions of this probation, Judge, we're just asking for you to allow him to at least transport her to the high school and ultimately possibly go back there at the residence, because again, Mr. Boyd is the custodial parent. The other alternative is, with all due respect, it's not a good alternative. So,
Sir, I don't understand your conduct here. You slap your daughter in the face?
Yeah, it was just
it was a stupid action.
Wait a minute,
And
a setup? Is that-
no.
Judge, what he meant to say is that he had a meltdown. As we know, a lot
No,
of
but
these.
we don't hit our daughters in the face.
Steve?
Yeah,
I'm aware of an incident that occurred. It was
Stupid.
Yeah, it was stupid. It was just, it's not, so I've raised my daughter from her talking about myself. That one moment is not a reflection of my parenting style or household or anything.
I believe you, but you really went off the rails.
I did.
Look, here's what I'm gonna do, and I'm glad you're mentioning this. I'm gonna adjourn the sentence and I'm gonna tell probation to try to get a hold of the victim and the victim's mother. And tell them the judge would really like to have them in here. At least by Zoom, Lisa. Maybe I can talk to everybody here. So let's adjourn.
Appreciate it.
Let's adjourn the sentence out. Is probation back? I know a couple of them were out yesterday. Are the couple of them out today, Lisa?
I believe Beth is here today.
Well, I'm debating whether or not I should go 2 weeks or 3 weeks.
I think 3 weeks, because it appears that Miss O'Donnell is on vacation this week.
Yeah, I'm gonna adjourn the sentence to June 30. So Lisa, would you email them and tell them what I'm thinking, that I would like them, Jessica, and you can CC Beth. I'd like her to make phone contact with the victim and her mother and see if I can't get them here, and maybe we can work this out.
Okay, I'll take care of that.
Make phone contact
Thank you.
with victim and her mother. Sir,
Yes, sir.
I can tell you're remorseful, but I just,
It was something that
I don't want to make you feel bad, but you cannot hit your daughter in the face.
I'm well aware of that, sir. It was honestly, it was a last judgment, a slip up in that particular.
Yeah, but that was a big slip up. And that permanently affects relationships, whether it's physical injury or not. And here I'm looking at some pictures here too that we'll talk about more in depth on the 30th. Why don't we make it at 9:30 on the 30th, Lisa? And
Okay.
hopefully they will arrange for themselves to be here in person. If not, I understand, but I'd like them here nonetheless, at least by Zoom. Okay? Thank you. Good luck. Go down the hall, get your notice, Philip Russell Conklin, 25R713371. And I also have 26R705091.
Judge, I don't have the attorney here. I've been trying to call him.
Mr. Garnick isn't here?
No.
Did you call his office?
Yeah, we've been round and round about this case. He doesn't reply to emails or phones, but the office talked to Amy on Friday and said that they would Zoom in for a waiver.
Oh, boy. Where's the defendant at? Philip Conklin.
He's at the
Okay.
police department. He needed to be printed, so they went and picked him up for today's hearing.
What to do? I mean, it's 11:40.
I can try and call him again.
Would you please?
Your Honor,
And
we're
then,
on.
Hi, Lieutenant. Listen, the lawyer isn't here. I'm ready to go, but the lawyer isn't here, so we're gonna have to call him. So I don't know if you want to put him back in lockup and wait for us to call you.
Yeah, that's fine.
It's up to you. We'll get a hold. When Mr. Gonick gets in, will you call
Oh,
Rockwood,
Judge,
please?
someone's in the waiting room. Let's see.
Okay, let's see.
Kayla
Maybe
Miller.
Oh, that's on her. That's on, good. People against Philip Russell Conklin, 250-713371. Good morning, Ms. Miller. Your appearance?
Good morning, Your Honor. Kayla Miller, P87446, standing in for the attorney of record, Ben Gonick, and appearing on behalf of Mr. Philip Conklin.
I also have 26R705091. Mr. Conklin, your name.
Philip Russell Conklin.
And Lieutenant, your name.
Detective Lieutenant Steve Mercury, Rockwood, please.
All right, so we have, let's take one thing at a time. I'm going to take the 713371. That's a May 11, 2025 felonious assault. There's a bond of $50,000, 10%, as I understand it. He is going to waive his right to an exam. Is that correct, Ms. Miller?
That's correct, Your Honor.
Sir, you're charged with felonious assault, the 4-year, and you have habitual fourth. So that means if you're convicted of it, you could get 15 years. That's a 4-year offense, but it could be a 15-year if it's proven that you have those 3 prior felony convictions, and if you're convicted on this count. Do you understand that?
Yes, sir. Yes, sir.
You have the right to a preliminary exam. By waiving your right to an exam, you're waiving the requirement that the people show that the crime was committed and that you were the one who probably committed the crime, and you'll automatically be bound over for further proceedings to the Criminal Justice Center in Detroit. Do you understand that?
You understand that? Yes, sir.
You gotta stay with me. Are you listening to me and understanding me? Do
Yes, sir. I hear you.
you understand everything I said?
Yes, sir.
You wish to waive your right to an exam?
Yes, sir.
All right. Anybody force you to give up your right to a preliminary exam?
No.
And you still wish to do that?
Yes, sir.
All right, I'll accept the waiver on that case. You're bound over for further proceedings. 50,000, 10% will be the bond. And June the 16th at 9 o'clock will be your court date at the Criminal Justice Center. On 26R705091, Ms. Miller, I know you already stated your appearance, but I just want to make sure he wishes to waive his right to an exam on that charge as well. True?
That's correct, Your Honor.
Is that true, sir? Are you listening to me, sir? Sir, are you
Yes, sir, I hear
listening?
you.
What's that?
Yes, sir. I hear you.
So is it true that you wish to waive your right to a preliminary examination on the other case as well?
Yes, sir,
There, you're charged with assault with intent to do great bodily harm less than murder by strangulation, which is a 10-year. You also have the 4th offense notice, and you have a domestic violence charge. If you waive your right to an exam on that, if you're convicted of something that carries with it 5 years or more, you could get life. Do you understand that?
I do.
And you still wish to give up your right to a preliminary examination on that charge?
Yes, I do.
Anybody force you to do that?
No, no.
All right, you're bound over for further proceedings to the Frank Murphy Criminal Justice Center on that. June 16th at 9 o'clock. Bond is 50,000, 10%. That's continued, same bond conditions on the charge contained in the complaint and warrant. Do you understand that?
Yes.
All right. Anything else, Ms. Miller?
Your Honor, if I may, would there be able to be a condition added to his bond where if he gets a bed available at Sobriety House, that he would be able to be transferred from the jail to Sobriety House to do inpatient treatment?
Well, I'm gonna let the circuit court deal with that in the event of a conviction. I'm not gonna change the bond. I'm sorry. I'll keep the bond terms and conditions in effect. If there's a conviction, you can ask the circuit judge, okay?
Understood. Thank you, Your
Nice to
Honor.
have you here, Miller. Thank you very much. Have a great day. Thank you. Good luck, sir. Thanks, Lieutenant.
Thanks, Your Honor.
You guys
Thank you,
ready
Your
to start
Honor.
on your exam?
Wait.
Do you have an exam?
Yes.
Is it going?
Mr. Michael should be.
Okay, I don't have the file, that's all.
I promise you, I got one more case. One more case. Let's take another bite of your own. Yeah, take it. You don't like it? It's okay. Shit. Let me show you. We have plastic baggies here, don't we, somewhere? Yeah.
I think.
Is the prosecution not proceeding? Is that what's going on?
believe so, Your Honor. Legal claim witness is not here. I tried to. I went here for a long time. Here.
All right, Ms. I need the file if you have it. Running around?
Yes. Yes. It's the best.
What's that?
It's one of the best places.
Well, thank you. You probably tell all the courts that, though.
Oh, no. No.
I got my assistant here today. She said, now what's taking so long? I said, we got one more. How you doing, detective?
Sorry about that, Judge.
Fine. All right, Denisia Charmaine Mendez, 25B 727-9152. Mr. Docs, your appearance.
Morning, Your Honor, great staff, to the Fulton Docks, pin number 79657, November plans, the desk, you said for it.
Denisia Mendez. And good morning, Your Honor, not only as on behalf of the people, PA 893.
Today is the date scheduled for exam. Are you ready to proceed?
Your Honor, at this time, people are unable to proceed. The original OIC on this case is Crystal Tullox. I did message her earlier asking about the subpoenas being sent. She did state that the witnesses were all served their subpoenas. The main complaining witness, necessary witness, Miss Cinnamon, I think that's her name, Cinnamon Warren. She was sent a subpoena. She stated that she was going to appear, however, she has not appeared. We have tried contacting her multiple times by phone. I do have a stand-in OIC standing to my right as well.
Dr. Renault Tar.
And he as well has tried contacting this victim in this case, and we are unable to get hold of her, so at this point we cannot proceed.
Yeah, I'm making a motion to dismiss.
Case dismissed.
Thank you.
I'll just make a note. People unable to proceed. Victim failed to appear.
Thank you, Your Honor.
What started as a routine court hearing quickly spiraled out of control. A defendant appeared before Judge McNally after repeatedly failing to show up in court. At first, he blamed mail problems and claimed he never received notice of his court dates, but the judge wasn't convinced. The court had sent multiple notices, and the defendant had already missed several appearances. As the hearing continued, the defendant became increasingly argumentative. He interrupted the judge, challenged the court's decisions, and even started using profanity in the courtroom. That was a huge mistake. Judge McNally immediately called out the disrespect and warned him to stop talking over the court, but the defendant kept pushing back. Then came the moment everyone remembered. "You want to play tough guy? Get in the WWE," the judge fired back. The courtroom fell silent. The judge increased the defendant's bond, warned him about his behavior, and made it clear that respect matters in a courtroom. By the end of the hearing, the defendant was apologizing and asking for another chance. But the damage was already done. One thing was clear. Arguing with Judge McNally is never a winning strategy.